Right, let's come in a little bit more on that and get reaction. We're joined by ATM leader Vuyo Zungula, as well as DA Public Service Administration spokesperson Dr Mimmy Gondwe. Good to have you both, and thank you very much for your time tonight here on In Focus. Dr. Gondwe, let's begin with you. This was meant to be a reputable and objective process run by an institution called a Section 194 Committee of Parliament. That's supposed to be really a respected institution that does its work with fairness. But we seem to be in a process where, or in a state now where it feels as though this process was overtaken by political machinations, and therefore the outcome unpalatable for some within that body called the National Assembly. What's your assessment on
it? Good evening, Thabo, and good evening to your viewers. I think as somebody who actually sat on the committee and day in, day out, listened to the evidence that was laid and adduced before the committee. And remember, Thabo, I think we agreed at the outset as a committee that we were not a court of law. And so our approach was going to be inquisitorial. In other words, we're going to embark on a fact-finding exercise in which we try and establish whether there is any credence or veracity to the charges that were preferred against Advocate Mkhwebane in the motion. And so, Thabo, it was really a protected process, and we witnessed to some extent Stalingrad tactics from Advocate Mkhwebane herself and her legal team. And at some point, it really it became too much. I mean, it was one recusal application after another, and the walkout. They maintained that they hadn't walked out, but what we saw was a staged walkout where we were literally left there as a committee. So, as somebody who sat, in that committee room day in and day out and had to listen to the evidence, I feel relieved that the process has finally come to an end, and we had such a large number of MPs voting in favor of her removal. Thabo, you also know that in 2016, the DA was the only party that was really opposed to her appointment as public protector. And we raised concerns, a number of concerns, not only about her character, but, in relation to her links to the State Security Agency. And we feel vindicated because during the course of the inquiry, a lot of evidence was laid that pointed to the fact that she really had close links with the State Security Agency. And a case in point is, the fact that we had one Dr. Moodley actually, input the Reserve Bank lifeboat, recommendation or remedial action that sought to actually alter the mandate of the Reserve Bank, something that, almost tanked our economy. In fact, it severely damaged our economy. Yeah. And so we feel vindicated, and we really hope it's a lesson to everybody that it's important to have the right persons in offices such as the public protector. I
want to circle back to that, what the chairperson of the committee calls conclusive, overwhelming evidence presented, and we want to go through it and allow also ATM to respond to it. But as your opening remarks, let's leave it there for now. But let's come back to you, Baba Zungula. I'm hearing words like honest. I'm hearing words like firm. I'm hearing words like it was a protracted process. I'm hearing words like, for example, the ballooning of legal costs, and so on and so forth. And so this process was given ample time to play itself out, even far beyond the mandate of this committee and what it was supposed to look at.
Thabo, there was no stipulated time to say that this committee must finish work on a set date. So that is something that is false to say the committee overextended its mandate in which it was given. Firstly, if we're going to talk about the genesis of this particular motion and the resolution that was taken today, when Advocate Mkhwebane was appointed to be the public protector in 2016, her appointment was challenged by the DA. Secondly, the DA went as far as calling her a spy, made all sorts of wild allegations which were not proven even today, meaning they've long hated Advocate Mkhwebane, not because of anything, but the fact that Advocate Mkhwebane was able, number one, to look into a complaint regarding the apartheid money that was stolen during apartheid times and seek that there must be justice for all of those monies that were stolen back then. Secondly, Advocate Mkhwebane proven herself to be someone that is not afraid to be independent and fights against the most powerful presidents and ministers in current cabinet. So in our view as the ATM, what happened today is nothing else but to incite fear in the minds of all public servants to say they must rule or they must do their work in line with the interests of the DA-led ruling party, or else they are going to be punished like Advocate Mkhwebane has been punished. So in our view, the process from the very onset, Advocate Mkhwebane had to beg or had to go to court for her to get legal representation. Meaning, if it was not for the court's intervention and Advocate Mkhwebane actually approaching court, would have had an inquiry, whereas the fundamental rights of Advocate Mkhwebane would have been trampled on. So the fact that Advocate Mkhwebane would have gone to court on a number of issues, it is something that is well and good, because that is what people must do. Whenever they're not happy about a process, they must approach the courts. And lastly, Thabo, on the question of course, it is Parliament or it is the DA that put through the motion. It can't be that now a narrative is going to be as if the costs that were incurred by this process are as a result of Advocate Mkhwebane. Similarly, with the State Capture Commission, which spent a lot of money and nothing has been done based on that State Capture Commission, but no one is crying about costs. And also on the question of costs, the cost of the evidence leaders, no one is talking about how much they were paid. The only narrative that is there is to seek to vilify Advocate Mkhwebane. So we need to get all of those facts on the table so that people understand what is truly happening and how this process is nothing more but to incite fear so that all public servants, they toe the line of the DA-led ruling party.
Why would, let's put the DA aside, let's put the ANC aside, but you have other parties, IFP, Freedom Front Plus and ACDP. Why are they also blinded to this fear that you're saying is being instilled on a public protector or Section 9 heads?
Look, Thabo, they can best answer on their own that particular question. But if you are going to be talking about the importance of an office of a public protector, particularly, Thabo, the institutions or the power that a public protector fights against, we'll recall that the former Chief Justice likened a public protector to a David that is fighting against Goliath. The Goliath meaning it is the banks, it is the state, it is the almighty and powerful, because we know there's a link between the banks, the mining sector, the politicians, because most of these parties, they are funded by the very same banks, the very same mining companies who want to remain or want to keep the status quo. Yeah. So with Advocate Mkhwebane finding against such powerful individuals, then it was most likely that these institutions or these mighty powerful banks and owners of the economy are going to unleash parties that they control in order to put through such a motion. So in our view as the ATM, this is clearly showing how our parties in Parliament are no longer acting in the interest of the people. Rather, they are acting in the interest of whoever that is funding them. Because Thomas Sankara put it very clearly, whoever funds you controls you. So the control of these parties has clearly been shown today.
Yeah. So you essentially would be saying the reason why the matter of the sub-CX report is being challenged even to the courts, where the courts also find it to be quite scathing, was to protect the apartheid bank. Is that what you're saying?
Indeed. Look, Thabo, let's talk about what people say that the public protector overextended a mandate. You'll recall that Advocate Madonsela said because Mr. Zuma is implicated in the State Capture Commission, he must not be the one that is appointing a chief justice, appointing a judge to oversee that particular commission. Whereas the Constitution is very clear on the powers that it is the president that appoints, no one else. It is the president that appoints a judge. Now, that is the clearest indication of a public protector actually making a recommendation, a binding recommendation that that when one looks at it, it is a violation of our Constitution.
Yeah.
Therefore, when Advocate Mkhwebane is saying that there must be a change in the mandate of the Reserve Bank based on the facts that were before her, people can now say that she overextended her mandate. Yeah. Whereas the same people did not find anything wrong when Advocate Madonsela...
Is it not the same courts that said, give her legal advice, and you accepted that outcome? But when the same court saying you extended your bounds, that's not where you were supposed to, because this matter was also ventilated in courts. You don't want to accept that outcome. It cannot be that you only accept outcomes from the courts when they suit what your outcome you want to be ultimately.
Look, Thabo, I'm placing facts before you that you've got Advocate Madonsela that is taking powers away from a certain president, that a president cannot do what the Constitution is saying must be done whenever a commission of inquiry must be set up in terms of appointing a judge. That is the fact there. Secondly, when Advocate Mkhwebane is also making a recommendation to Parliament on what must be done. Now, it is the very same principle here, because you're talking about this very same office of a public protector making a recommendation, that takes away powers from or changes or alters the powers of either Parliament or instructing the President on what to do. It is the same thing. So the point that we want to get across here is that there can't be now people that are going to find it okay for Advocate Madonsela to do that, but find it wrong when Advocate Mkhwebane is doing the same thing on the question of principle.
All right. Dr. Gondwe, how do you respond to that particular assertion? Because I want us to look at the evidence that was presented. Let's look at the evidence presented on the SAICS report that led the committee to reach a decision that there was misconduct and incompetence.
Thank you very much, Thabo. Thabo, you'll know that we established a finding of misconduct in relation to the Reserve Bank lifeboat report on a number of grounds, and I want to touch on three very important. The first one was that she had meetings with the State Security Agency, and she didn't disclose, that when the report was now being scrutinized, she didn't, and she didn't even disclose that in the Rule 53 record. In fact, we heard evidence from one of the investigators indicating that she, directed him to not record the meeting that they had with the SSA. And so the committee was able to establish that she had these undisclosed, meetings with the SSA, and she solicited input and advice from the SSA on, the remedial action for that particular investigation report. And to add to that, Thabo, was that then she then took the recommendation, the remedial action that Dr. Moodley actually formulated or articulated, verbatim, word for word, and she put it in the report. And the consequences of that particular report Thabo, as I indicated in my opening, were so grave that they almost tanked the economy. In fact, they really severely damaged our economy at the time. And so, Thabo, our concerns there were that she went too far, in the sense that you cannot have a party that is also implicated in an investigation or formulate a remedial action, and she didn't even solicit any inputs or advice from the Reserve Bank, for example, from Treasury, or even well-known economists or academics. And to top it all off, Thabo, you will also know that on the basis of her remedial action, and that she put in that particular report, we were able to establish as the committee that there was no connection between that remedial action and the concerns that were raised around the matter under investigation. So in other words, there was no nexus between that remedial action around amending the mandate of the Reserve Bank and the remedial action that that was in the report. So there was no connection.
So where these
investigators around that,
were these issues in terms of procedure, right, and proper processes of Parliament, were they debated exhaustively to the point where all parties might not agree, but it reached a point where back and forth between your view and Mr. Zungula's view and anybody else in that committee would have had a view? They were all ventilated to a point then that the committee would draw a conclusion based on the various views that were brought in. And would that have been a fair process?
Thabo, as far as I'm concerned, the proceedings of the inquiry were fair. They observed the rules of natural justice. I mean, it's a pity that when we accorded Advocate Mkhwebane an opportunity to come and tell her side of the story, she didn't. You could see that she was ducking and diving. I mean, I even said to her at one point during the inquiry that I look forward to hearing your side of the story, but she didn't. And so we had no choice but to rely on the evidence that had been laid and had been reduced by the evidence leaders, as well as the evidence that we had heard from the various witnesses and other documentary evidence that was, brought before the committee. And so we never really heard from her side, and we gave an opportunity. And I just want to talk about the issue of legal representation. No one denied Advocate Mkhwebane the right to legal representation. If anyone did, it was her. It was her and her legal representatives, because there's a point where they even staged a walkout. I mean, we bent over backwards, Thabo, in terms of ensuring that she had legal representation. She had the funds. At some point, she even raised the issue of the funds with the committee, and we said, well, it's not really within our purview. But the chairperson then took it upon himself to engage the Minister of Justice and to also engage the chairperson of the PC on Justice around the issue of the costs of a legal representation, and around whether or not there was a timeline to the inquiry. Indeed, there wasn't, but we couldn't have an inquiry that was endless. And I mean, Thabo, we spent over 10 months, 14 months, if I'm correct, just on this inquiry, which cost more than 160 million rand. I mean, what were we expected to do? To bankrupt the state? And spend more money on this inquiry.
Well, the argument is that a similar process happened with the Commission of Inquiry, where we spent $1 billion, and it was justified.
But its scope was much wider than
the billion compared to the amount of money that was stolen in the country would be justified.
But the scope of that inquiry was much wider than this one. And there were so many players in that inquiry, and in that inquiry, and in this inquiry, we only had one person that was, the subject of scrutiny, and that was Advocate Mkhwebane. It wasn't, Honorable Janchi, it wasn't Honorable Mayhem, or anybody, or the evidence leaders, or anybody else that her legal team, requested that they be recused. And there's no denying that this this inquiry was initiated or was birthed by a DA substantive motion. I mean, that is common cause. It's not even a secret. But the point is, I feel that today the right thing happened and we did justice by our country, by our people, and by our Chapter 9 institutions and people that are relying on those institutions to keep government in check. She was no longer serving the interests of the country or our people or even the office that she was occupying. If anything, she's done everything to denigrate and degrade its stature and its reputation. And we didn't even have a chance to touch on some of, the stuff that came up during the inquiry. Stuff like...
Absolutely. The Freighted Dairy Farm issue, there's a rogue unit. I mean, we're just not going to have time to touch on all that and what your findings were. But
her use of external consultants such as Ngobeni, Kim Heller, Professor Sepe, how she, she employed her political advisor, the late Mr. Nyembe, so many, and how Mr. Paul Ngobeni would, bill attorneys for articles that he was writing in her defense and attacking members of the judiciary. I mean, there was so much that we were able to unearth, during fact-finding, exercise that we undertook as the committee.
Ms. Zungula, as a member of the committee, how did you process the evidence, for example, presented by Advocate Debogo Kekane, a former senior investigator in the Public Protector's Office who worked on the CX investigation? Mr. Zungula?
Yeah, I can hear you now.
Can you hear me? I'm saying, how did you process the evidence of Advocate Debogo Kekane, who is a former senior investigator in the Public Protector's Office, who testified that the recommendation was not in the preliminary report on the matter, but materialized after two unusual meetings with members of the SSA?
Thabo, just like Honorable Gondwe has just confirmed now, that advocating the report or the conclusion was actually done or concluded without taking the view of Advocate Mkhwebane. That clearly shows that there was no justice, because you can't reach a conclusion without the views of the affected party. You'll recall that even when the advocate was still on the stand, they were abruptly cut from her testimony there. Therefore, on the questions of Mr. Kekane, we are of the view that it is Advocate Mkhwebane who was in the right place for her to actually account and actually state from her side as a public protector as to why all of the things that were alleged by Mr. Kekane actually happened. So in the absence of Advocate Mkhwebane actually providing her side of the story will always be incomplete, because it is told on the side of Mr. Kekane and the other people. But the person who was integral to the process was not given an ample opportunity for her to state a case.
Yeah, and that's the argument now, to say she was. I mean, with the assertion by some in the committee, including the chair, that at some point processes were halted to ensure that she gets legal representation, that her funding issues are dealt with, and so on and so forth. Would you say that would have been a fair way of dealing with the process?
Look, the Constitutional Court actually confirmed that Advocate Mkhwebane has the right to legal representation throughout the entire process, legal representation of a choice. And when President Ramaphosa suspended Advocate Mkhwebane, he was very clear to say she's suspended. However, all of the rights that accrue to her, they will not be trampled on. In other words, her right to legal representation paid for by the Office of the Public Protector, she was supposed to be getting that. So it is only throughout now the continuing of the process that the Office of the Public Protector stated that there's not enough money, there's some funding issues when it comes to funding the legal representation of Advocate Mkhwebane. But that is not the work of Advocate Mkhwebane. She did not, number one, call this inquiry. She did not suspend herself. And the fact that what is very clear again is that the work that she was doing as a public servant, just like ministers and the president and all other people. Whenever they are taken to court, it is the state's money that is being used to defend them. So why is it now people are going to want Advocate Mkhwebane to be treated differently, whereas every minister, mayor, and public servant, whenever they go to court being represented by taxpayers' money. So that is why you find that the narrative of wasting taxpayers' money is only applicable to Advocate Mkhwebane. Nothing is being said by all of these other premiers and all other people who go to court based on the work that they were doing whilst in office. And what is very clear again is that Advocate Mkhwebane, had a right to say the attorneys that have been appointed by the state, she may not be comfortable with them simply because it is the very same state attorney that appointed the evidence leaders. So in our view as the ATM, you'd remember that when the attorneys were appointed and they wanted to have time to actually acquaint themselves with the process and the inquiry so that they brief advocates, and the committee did not afford them such time. So, Thabo, there was blatant bias there, and it was evident for anyone to see.
Let's leave it there for tonight.